My name is Dean Armstrong. I'm the joint head of the 36 Group. I'm very pleased to be co-presenting this presentation to you with Andrzej Bojarski, who is a member of the family team and obviously a member of 36 Group.
Hello, everybody. I'm Andrzej, family barrister, as Dean says, at the 36 Group and head of the family finance team. I'm going to be speaking a little bit later on in this webinar, but first I'm going to hand back to Dean, who's going to introduce the topic of crypto assets as property to you.
Thank you, Andrzej. I'm very grateful to you. Crypto assets as property. Now, clearly a hot topic. And what we're going to move to is a statement of intent given by Sir Geoffrey Voss, who is the Chancellor of the High Court. That statement is based upon a task force which effectively reported on the importance and the ever-growing importance of crypto assets in English law. And we see the statement there dealing with the desire, effectively, that crypto assets should be recognized along with smart contracts as giving binding legal obligations. I'm pleased to say, and we'll discuss this later as we go through, that that statement of intent given by the Chancellor has borne fruit in terms of the state of the law as we now have it in this country. So the challenges of cryptocurrency, crypto assets, and the reason that these are important, particularly in relation to divorce settlements, financial settlements arising from a divorce situation, are that those of you at the sharp end in the front line of giving advice to those affected by this need to understand the nature of what is actually a relatively new concept. So some of the things we're going to talk about today are going to be the following. Are crypto assets, in particular cryptocurrency, is that property? Is it divisible? Is it capable of valuation? Where can they be located? And there are obviously other concerns dealing with money laundering, terrorism, secrecy, and the like. So moving on then to an overview of what cryptocurrency, crypto assets are. And there are clear differences between what we call fiat money, ordinary money, the money that we're all used to dealing with on a daily basis, and cryptocurrency. And it's important that we start to understand and appreciate that we're talking about an entirely different character of currency here, or currency of asset. Fiat money, as we know, is physical. Of course, we are very used to doing transfers digitally, etc., in terms of moving money around on our online banking. But that's not the same as the fact that what we're dealing with in cryptocurrency is we are dealing with something which is digital. It's actually a piece of computer code, effectively. And so the representation is by one piece of private and one public piece of code. And when I talk about cryptocurrency here, my comments are general, but the one currency or the particular currency you're most likely to meet in practice is going to be Bitcoin. I don't suggest, for example, that that's exclusive. Ethereum and other coins are well represented increasingly, but at the moment, Bitcoin is the one which perhaps is most familiar and most widely used in society. So, fiat money issued by a government, and this may be a part of a wider challenge as we get used to use of cryptocurrency in the future. But cryptocurrency is not issued in the same way that a government issues currency. This is issued, or more particularly, it's produced, created by computers, because, as I've said before, it's a piece of computer code. Fiat currency is centralized. As we know, the banks control its issue, the banks control its supply to a degree, the banks set rates in respect of borrowing and the like. So there's a centralized function that the banks, in particular the Bank of England in our particular circumstance, that performs that role. Cryptocurrency, by its very definition, is decentralized. There's no control by any entity, and that's very important as we look to how it's used, who has control, who has an ability to regulate. And one of the challenges that certainly those of us who practice in cyber law, in cryptocurrency law, in the new way of thinking in terms of currency and assets, we will have to deal with those challenges, the lack of centralization creating an apparent lack of control. So what is one of the particular circumstances which follows in relation to this? Well, in relation to fiat money, as we see there, the value is determined by the market and by regulation. To a degree, that can be said of cryptocurrency, but it's different because the value is determined by supply and demand. And one of the issues that we'll deal with later in this discussion will be the potential issues surrounding volatility of currencies which are not centralized and determined by regulation and market. As we've said, cryptocurrencies are money that exists in electronic form only, and it's important that that mindset, how we think about money, changes when we're dealing with crypto assets, cryptocurrency. We obviously are used to dealing with physical money, money which we can see, money that we can touch. Very important when we're dealing with crypto assets, cryptocurrency, that we completely lose that as a concept. Cryptocurrencies exist in electronic form only. They are not held in a bank account. They are decentralized, as we've discussed, dealing particularly with Bitcoin, but also Ethereum. They exist on a blockchain. Now, the blockchain is a decentralized ledger, effectively a list, a series of entries, again, via computer code, which show and report details about that particular piece of code, that cryptocurrency. And as we say, they are anonymous. A £5 note in circulation has a serial number, but obviously its use is moved from person to person. What the blockchain can do can also have a function in terms of locating that piece of cryptocurrency, crypto asset, but what it can't do, and this may be a challenge and will be a challenge for those of you who are seeking to divide assets related to crypto assets, no one knows who owns the wallet. And as we'll discover later on, it's usually possession being 9/10 of the law in this particular circumstance, which can cause issues when assets are being divided. The important features to consider as we move through this is, and this has been, as with many new technologies, the courts are doing their best to catch up with concepts and how those concepts can be regulated through the courts. You will know much better than I, as family practitioners, that Section 25, Matrimonial Causes Act 1973, there has to be regard to the income earning capacity and, I've highlighted there, property and other financial resources of the parties to the marriage when making financial provision orders. So a core concept, a key central concept is what is property as regards crypto assets in particular. The law, as we say there, has traditionally recognized two types of property, things in possession and things in action. Cryptocurrencies, as we've discussed, being computer code effectively, are on the face of it neither of those. They are pieces of data. Does that then mean that they're incapable of being classified as property? There's been a huge debate raging over this. The courts have done their best, and as we shall discover later on, appear to have found assistance for practitioners as to where crypto assets lay in relation to their classification as property. But let's just look at some practical issues which arise from dealing with an asset which is not either in the traditional mold of what property is recognized as, but actually is frankly just simply a piece of data. Well, first of all, crypto assets as property, does it really matter? As we see there in relation to the three references, two cases and a statute, the courts have not been slow to recognize intangible assets as property. And so even assuming and using a narrower definition, that does not in and of itself mean that a cryptocurrency cannot be treated as though it were property. So that's the first practical consideration. Another, and the second for these purposes, is, moving on to the next slide, it probably is property. Now, when I first put these slides together, effectively the case was not completely closed as to what the court's attitude and approach was. The very first foray into this area of classification of whether it was property, crypto assets were property or not, really came in the case of Robertson. And that was, whilst it's interesting to note, we're now in March of 2020. The first forays effectively into this were relatively recently, August 2019. And there, the commercial court made the very first steps really towards classifying, or more importantly, recognizing crypto assets as property by granting an asset preservation order for over £1 million equivalent of Bitcoin, which had been stolen in a cyber attack. The significance of Robertson, and one of those cases where it was difficult to, it's not a reported case, but Robertson made that first foray, as I say, into a recognition of crypto assets being property. At that stage, as we point out in the slide there, it was an interim remedy, because what was being awaited was the, I won't say decision, but the guidance that the UK task force, the UKJT as it's come to be known, was going to be given. And that statement came a little later after Robertson. That came in November of 2019, and the statement on the status of crypto assets and smart contracts was the one that I started this presentation with, where the task force expressed the view that crypto assets are to be treated in principle as property. The courts at that stage didn't have any domestic authority to gain support from, but they gained support from the case in Singapore, which you'll see there, and one of the judges, Simon Thorley, sitting in the Singapore International Commercial Court, accepted Bitcoins could be the subject of a trust and thus were property, and also observed that cryptocurrencies have the fundamental characteristics of intangible property as being identifiable thing of value, and they meet the National Provincial Bank, which is the classic statement on the law of property, meets those requirements. So the observations of the UKJT, as it came to be known, were that crypto assets have all the indications, indicia, of property, that the novel and distinct features did not disqualify them from being property. And the fact that they are not disqualified from being property because they are simply information means that they may not be classifiable, but it doesn't mean to say, as I say, that they can't be property. We have been recently enormously helped before we move on to the next slide, with a more recent decision. So and I'll give the reference here because it is of great use to practitioners, the case of AA against Persons Unknown 2019 EWHC 3665 commercial, and that was a judgment on the 13th of December 2019, which effectively had huge implications for cryptocurrencies as property. This was an application by an English insurer, AA Limited, which had paid a ransom in Bitcoin to persons unknown following a computer hack. And as often happens in those situations, there had been a blackmail and an extortion which followed. Significantly, one of the features of the case was that the judge, Mr. Justice Bryan, found that publicity would defeat the purpose of the application for relief, and it would tip off the wrongdoers holding the asset, the Bitcoin, which inevitably would lead to dissipation. There was also issues involving confidential information ensuring the insurer's processes. And the court recognised there was a risk of reprisals or copycat cyber attacks on the applicant if too much publicity was given to the action. So, what did the court decide? The court decided that in respect of this action, was a proprietary injunction appropriate? And in order to decide that question, it had to decide whether Bitcoin, in this particular case, constituted property. Mr. Justice Bryan, considering the UK JT's legal statement, the one we've just been discussing, came to the view that it was property. He found that the statement, not a statement of law, i.e. the statement by the UK JT, was a detailed and careful consideration, his words, of the matter, and its analysis was, he found, compelling. The court concluded that cryptocurrencies such as Bitcoin are property, and that they met the 4 criteria set out in the National Bank case, Lord Wilberforce's classic definition found in 1965, as being definable, identifiable by third parties, capable in their nature of assumption by third parties, and having some degree of permanence. The court also noted that 2 other authorities where cryptocurrencies had been treated as property, although had not considered the issue in the same depth that the AA case had, he also decided that they were correctly decided. Brian Jay's conclusion was that cryptocurrencies were a form of property capable of being the subject of a proprietary injunction. And thereby we had the first and most significant recognition that we were dealing in terms of crypto assets with property. This journey makes practitioners' life much easier because we can then work on the basis that there is authority to say when you are dealing with financial settlements that crypto assets, certainly Bitcoin, and that's clear here, Bitcoin can be classified as property. So, what are the practical implications? It having been decided that cryptocurrency is property, what other challenges are there? Well, again, practitioners in your area will understand the difficulties of division of assets. Crypto assets clearly can, in principle, be divided and can and should be available to the court to the subject of a financial provision order. But not all crypto assets are easily divisible or easily transferable. The CryptoKitties figure that you see on the left-hand side of the screen there, as you look at it, is an example. Some of you may not have heard of CryptoKitties. CryptoKitties are actually features of a game. It's an online game where you can breed and buy and sell crypto cats. And before that is dismissed as being something of a frippery, actually, to let you know, £1.3 million was spent as of late last year on this game, this online game. And some of the rarer crypto kitties that you can buy actually go at a value of over $100,000. So there's an example of how online assets can actually be very valuable. I shall leave it to you to think of novel ways as to how you could divide a crypto kitty on a financial provision order. And the Tom Cabinet case there is a relatively recent ECJ judgment, which you might have heard because it's an important case which separates the distinction between physical books and e-books. And what that decides is that the copyright in e-books can't be exhausted. So again, things like that are more difficult to divide when one is dealing with those kind of crypto or digital assets. Other ways, moving on to the next slide, that may have significance for practitioners advising people in terms of their entitlement to digital assets is where investments have been made in businesses, but through a digital avenue. A lot of you will have heard of ICOs, less popular now. STOs have rather taken their water, but an ICO is a digital way of raising funds from the public through virtual currency or cryptocurrency. Similar in outlook to an IPO, but obviously it's digital, almost always raised in digital currency, very much raised in recent times where money's raised in Bitcoin. But again, when you are advising and examining finances of those who've made assets and valuing those assets and that investment, it's not always straightforward to be able to deal with what the equivalent investment would be in terms of financial provision order if that had been in fiat currency, which ultimately is what you have to currently do based upon where we are in terms of the practical applications of financial provision orders. So moving on, ICOs are very broad. As I say, they're the digital token. They represent a share in a firm, company. It may be a prepayment voucher. It may have no intrinsic value at all. And I mentioned earlier about STOs, security token offerings. They have a much more of a proprietary interest, but again, not always easy to identify. A lot of this will be accessed through the blockchain. Again, a digital ledger isn't completely easy to find where particular assets are held. But I'm a great believer of the blockchain, and the blockchain is increasing in its use. Bitcoin lives on the public blockchain. Most particularly these days, private blockchains are springing up. Public blockchains do have, in my opinion, issues with regulation and conflict with GDPR in particular. But one of the aspects you'll have to deal with will be, how do I value these new digital assets? How do I access the blockchain to show where the assets are? How do I deal with volatility? How do I deal with division and fair separation? And that volatility is something which does cause issues. There are movements to stable coins becoming much more part of the crypto asset scenario, because they tend to be fixed, or at least have a reference point with fiat currencies. But the issue with Bitcoin is it is incredibly volatile for the reasons, or one of the reasons that we looked at earlier. It's not fixed to any particular market. It effectively, so it can swing. And as we say at the top there of that particular slide, fraction of a penny in 2010, £1,000, $1,000, I should say, at the start of 2017, and then almost $20,000 in December 2017. Then there were the falls. Bitcoin in our current uncertain financial market is increasing in value. But the difficulty is, the longer the period between the proceedings starting and concluding, the greater potential for volatility. So that's a challenge for practitioners. Just a word before we move on to the next stage about where Bitcoin, and as I say, I've used this prior to moving on to the money laundering and terrorism point, but Bitcoin is stored in online wallets. It's effectively stored in potentially in three different ways. There's software wallets, there's online wallets, and there's physical wallets. I'm not going to give you a long and involved lecture and discussion about the three in particular, but it's worth knowing, first of all, how you can, dealing with the particular situation you're dealing with, where the asset is. It is right to say, and I know Andrzej is going to deal with this in a little more detail as we, in terms of practicalities, but one of the issues that you will face when advising people is physically where is the cryptocurrency, and physical possession of the wallet is often of huge significance as to an ability to actually get your hands on, or get hold of, or make that asset available. But as I say, I just flagged that up, and I know Andrzej is going to talk about practicalities in his discussion with you later. So moving on, money laundering and terrorism. What has to be very much in the forefront of anyone who was advising on crypto assets are the obligations which are imposed by the Money Laundering, Terrorism, Finance and Transfer of Funds Regulation 2017, recently amended. I say this month, I think it was, when I wrote this, it was the end of last year. And the reason that it's important is providing an ability to do the checks that all practitioners are obliged to do. So ascertaining the provenance and the purpose, ascertaining as much as you can where the source of funds has come. And as I say at the bottom in that paragraph, when managing client money, security or other assets, or assisting, planning or executing such a transaction, practitioners must assess risks of money laundering and terrorist finance. And often these transactions are large and complex. What also has to be borne in mind as an adjunct to this is that we're also into territory now of the 5th AML directive coming into force in January 2020, which also brings within its auspices crypto assets. So there are greater obligations. And so one of the compliance issues that must be borne in mind as soon as one is dealing with a crypto asset situation in divorce, for example, is the important and increasingly sophisticated obligations imposed upon professionals in terms of their checks in respect of money laundering, terrorism, finance, sanctions, and the like. So where we end up in terms of this first part of the discussion is that I've said that there is no certainty that crypto assets and cryptocurrency are property in law. I think I can now amend that to say that with the AA decision, we are pretty much free and clear as regards that development of the law. And as I say, it all happened very quickly. I think the judgment in AA was actually not published until mid-January. The courts are willing and have shown willingness to treat them with a practical aspect and treat them as property, to treat them as more recognizable beasts as the ones that we deal with on a regular basis. It is clear, therefore, that you as practitioners will deal with the challenges on an increased basis of crypto assets. You need to be alive to these features. They are difficult to value. They are difficult to find. But there are experts, as with everything, there is an increasing body of experts to assist in valuation, in ensuring that a fair outcome is achieved. Remember, when you are dealing with crypto assets, that your obligations as a legal professional are greater, because it is important that you, on a risk basis, a risk-averse basis, as it were, assess or do as much as you can to ascertain the source of crypto assets and funds. So with that, I shall hand you over to Andrzej.